welcome everyone. On behalf of Benefit Express, we'd like to thank you for joining us and taking the time out of your afternoon for our webinar on issues with COBRA administration and how to fix them. We have Larry Virgin, ERISA attorney, who will be administering the webinar today, and he's a great resource for questions, so please feel free to ask away. He'll pause for questions. I'm going to keep everyone on mute, and that way, if you have a question, he'll unmute, or you can ask the question through the questions tab in your GoToWebinar toolbar, and I'm happy to ask it and find the answer out on your behalf. I sent out the presentation slides earlier today via email to everyone. I did get a couple bounce backs, but for the most part, I hope you received it. Also, it's in the handouts tab of your GoToWebinar toolbar as well, if you wanted to print it out quick and take notes. Our next webinar will be on Tuesday, 4/19, and that will be 2016 developments in HRA administration, and we'll be reviewing recent IRS guidelines on that. I think Larry will talk a little bit more about that, but if you'd like any more information on Benefit Express and how we can help you guys and with our services, we're happy to do a quick, easy demo for you. You can contact me, Stacy Ryan, S. Ryan at mybenefitexpress.com, and I'll turn it over to Larry.
Well, thank you very much. In regard to the seminar on, I know one thing I just want to say, if I sound a little different, I have a cold. I've been trying to shake it for a week, and so hopefully the next time you hear me, I'll be a lot better, but I'm on the tail end of this cold. So on the 19th, I'll be talking about all the IRA developments over the last couple of years. Also, the recent developments of any product or any plan that's been around, those were hit the hardest in the changes, the laws, and it's hard to keep up with over the last couple of years how ACAs affected HRAs. So I put everything together in one presentation to make sure that everybody understood all the changes, because there are some very interesting new requirements under HRAs that maybe you weren't aware of, that have been around for a couple of years, and it's good to just understand exactly if you're sponsoring an HRA or want to sponsor one, what do you have to do to keep up with the law. In regard to today's presentation, what I've tried to do, because I help people with their COBRA administration, and this presentation is highlighting some of the issues and problems with COBRA. COBRA is very complicated, very convoluted, and there's some areas that there's issues with, and what I try to do is take 11 or 12 of them, have a discussion of exactly what to do, and unbeknownst to me today, and one of my clients, one of the areas that we're going to be discussing was the question they had. So this is based on questions I've been getting, issues I've been getting from my clients. So these are based on true-to-life situations that you could have with your COBRA administration, and I'll be talking about what the issues and problems are and how you can fix them, because the problem is that the DOL, this is one area that DOL is auditing employers on, and this is one area that if somebody isn't offered COBRA, the issue and problem is going to be is that one of your former employees who could be disgruntled, and if they weren't treated properly with their COBRA administration, could complain to the DOL, and the DOL does investigate. So it's good just to make sure, and even if, and this is really important, even if you say to yourself, well, I mean, I have a COBRA administrator. I hired somebody from outside, a third party, to administer my COBRA. Doesn't matter, because even I had one situation where somebody didn't give the proper amount of people who terminated to the COBRA administrator. So there was a disconnect between the COBRA administrator and the person administering. They missed 3 or 4 people offering COBRA, and there was a problem. So just because you hire a third party doesn't mean as an employer you're going to be completely off the hook. Now, I'll be stopping periodically to take questions, and the advantage of this is the fact that we'll open up for questions, so you can, if you have a particular situation you want to address, if you want to send Stacy a question, there's the questions tab on your toolbar. Now, assuming COBRA doesn't apply to you, and this slide talks about the special rule that indicates that you have, if you have less than 20 employees, that you don't have to offer COBRA. So it says here, the general rule is that COBRA applies to group health plans maintained by employers that have 20 or more employees. The issue and problem is that this calculation is generally in the prior year, and it's based on having less than 20 for so many weeks. Now, one thing that some people forget is the fact that this is based on a control group basis. So just because your company has less than 20, if your employer owns other companies, that's all put together to see if you comply with that requirement. And so it's important to understand what this exception says. So in general, COBRA will apply to employers that have 20 or more employees or more than 50% of typical business days in the previous calendar year. So if you dip below 20 in the current year, it doesn't mean you can automatically stop COBRA. It also doesn't mean that you can get rid of anybody on COBRA that took it in the past. So it's extremely important that you understand that when the exception does apply to you. So as your staff levels, and again, because of the recession, this was a popular question in 2008, 9, and 10, the companies were laying off people, and they were offering COBRA, and they were asked, well, at what time, we're reducing our staff levels, do we have to not offer COBRA any longer? Well, again, please understand that in the current year, if you go under 20, it doesn't necessarily mean that COBRA doesn't apply to you. Also, in counting the number of employees, again, you have to look at common control, and also you count both full-time and part-time people. A part-timer counts as a fraction. Divide the number of hours the employee worked by the number of hours required to be full-time. So again, just because you have full-timers doesn't mean you may not be over the 20 limit. Now, once you have determined that COBRA applied to you, the next step is to figure out whether your health plan is subject to COBRA. And I get this all the time. Questions and issues about, okay, what plans do we have to offer COBRA to? And COBRA applies to group health plans maintained by employers. Now, what's important here is the term maintained. It applies to technically employer-sponsored programs. So if you have situations where benefits are voluntary, COBRA may or may not apply depending if the program is endorsed by the employer. So generally, at some employers, there could be benefits, voluntary benefits, and if they truly are voluntary benefits, COBRA doesn't apply because they're treated as individual products. But as soon as you put these voluntary benefits through a cafeteria plan, the argument is it makes them a employer-sponsored program. Also, what's important, COBRA applies any time that arrangements provide medical care. And I'm shocked and surprised where some of the voluntary benefits, and you have to talk to your voluntary benefits provider, how many times those benefits actually include medical care. They provide some type of medical care, so you have to check with your provider. This is important, for example, not only for COBRA, but for eligibility for HSAs. Because some of these coverages do provide medical care. So on this next slide is examples of health plans that may be subject to COBRA: medical, dental, vision, prescription drugs, drug and alcohol treatment programs, employee assistance programs or wellness programs. Employee assistance programs are considered medical plans if under the employee assistance program it provides benefits beyond a referral. So if you have a nurse helpline, if you have any kind of counseling, that will be considered to be medical care. Also, on-site health care, health FSAs and HRAs, and self-funded medical reimbursement plans. All have to be offered COBRA and are subject to COBRA. So again, and I've had arguments with different insurance companies about employee assistance programs and whether they're subject to ERISA, but there's established DOL guidelines on this, so that indicate in certain situations when EAPs are subject to COBRA. And in that situation, it'd be if you offer, again, a nurse helpline, any type of counseling, then that would be subject to ERISA. In the counter is, well, my EAP is in my disability plan or in my group health insurance, group life insurance program. It doesn't matter. If it provides medical care and it's employer sponsored, then COBRA would apply. Now also, the following are examples of plans are not subject to COBRA: long-term care programs, accidental death and dismemberment, group term insurance, long-term and short-term plans, disability plans, wellness programs, and employee assistance programs that do not provide medical care. So if your program just provides referrals to other providers, then it doesn't. If you have an exercise or fitness centers or on-site first aid facilities that don't provide substantial care, in that situation, then COBRA does not apply. Now, this is the issue that came up today. This one right here on this slide right here. Another potential pitfall to keep in mind is assuming that the canceling or terminating health plan means that COBRA obligations terminate as well. If the employer terminates one plan but continues to provide a group health plan, the obligation to provide COBRA coverage continues. In this situation, there were 2 or 3 companies in a control group, and what happened is one of the companies was going out of business. So they were terminating their health plan and terminating their employees. And I said, well, does any other member of the control group offers health care? Yes, it's with a different provider. It doesn't matter. So in this situation, one of the exceptions where you don't have to offer COBRA if you're terminating your health coverage. But make sure that no other entity in the control group does offer a medical plan. Stacy, why don't we stop here and see if anybody has any questions?
Okay. I have one on my end. Can you please explain what is considered a control group?
Control group, basically, there's different types of control groups. There is parent sub, where one company owns 100%, at least 80% of the other company. That's called parent sub. Another part of a control group is called brother-sister, where the same 5 or fewer individuals own 80% of each entity. Another type of control group is an affiliated service group. Those are basically with professional services, where one entity is tied to another entity. They provide services. In those situations, when you have a control group, technically, under the law, under the tax law, it's considered to be one entity. So for ACA purposes, for non-discrimination testing purposes, everybody in the control group because of common ownership. And it doesn't matter in this situation if they have different EINs, different structures. It all is based on ownership. And there's very complicated and detailed rules in what is considered to be a control group. Those rules are extremely important because it affects all aspects of providing benefits. And as I said before, ACA reporting, for example, in determining whether you're an applicable large employer, that's all done on a control group basis.
Okay. Next question, and hopefully you'll know what this is referring to, but it just says 20 benefit eligible employees, question mark.
No, it's 20 employees.
Okay, 20 employees. Okay. Next question, last question on my end. We do billing for leave of absence since they are not doing payroll deductions. If they do not pay, we are terminating due to non-payment. Is failure of the employee to pay their portion and terminate due to non-payment a COBRA qualifying event?
There has to be, in order to be a COBRA qualifying event, there has to be two things. There has to be a qualifying event and a loss of coverage. In this situation, their reduction of hours didn't cause them to lose coverage. It's because of not paying the premium. In a situation that's a similar situation, if somebody is on family medical leave, and during the leave they don't pay the premium. In regard to family medical leave, that's not considered to be a COBRA qualifying event. Only when they announce they either not coming back to employment or at the end of the family medical leave is that considered to be a COBRA qualifying event.
Okay, and then the last part is, do we have to offer COBRA if they refuse to pay their portion?
No.
Okay. Okay, let me unmute for questions. Just be mindful when I do unmute that we can hear you, so if you can mute on your end unless you have a question, that'd be great. Thank you.
The conference has been unmuted.
Does anybody have any questions? Anyone?
Actually, I do. Hello?
Yes. Yeah, go ahead.
Okay, so here's my question. You were just talking about qualifying events for COBRA. I had an employee who was on COBRA and had reached her end date for COBRA and wanted to know if that was considered a secondary qualifying event for her.
No.
Okay, I didn't think so. Just wanted to make sure. Thank you.
Yeah, it's got to be, and again, we'll do another general COBRA session in the future, just go through all the rules.
Okay.
You got to be real careful because in some situations, for example, a very common situation is at open enrollment, an employer will drop family members for one reason or another. And in that situation, people will come to me and said, well, do we have to offer them COBRA? And my answer to them, well, what's a qualifying event? Was there a divorce? Was there a termination of employment? Was there a reduction of hours? There was merely a loss of coverage.
Okay.
And so therefore, there's no reason to offer COBRA in that situation. So just be careful to understand there's got to be two things. One of the recognized qualifying events under COBRA, and then there has to be loss of coverage. And those two things have to be there in order for you to offer anyone COBRA. Anyone else have a question?
I do, really quickly, just regarding understanding if you terminate a plan. So if I have two plans, let's say a base and enhanced, and I get rid of the enhanced plan, do we have to offer COBRA coverage in that instance, or can people just now enroll into the base plan?
Well, remember, just because there's a loss of coverage, there has to be a qualifying event. So if you get rid of one plan and people have the ability to switch to the other plan, there's no COBRA qualifying event.
Okay, I see.
You know, people are kind of hypersensitive about stuff like this, and I can understand why, because some of this stuff can get rather complicated. Any other issues or questions?
Yeah.
Go ahead.
Well, and not only that, but you don't let
Anybody have any, remember everybody, we can hear what you're saying. So does anybody have any other issues or questions?
Yes.
Yes, go ahead.
Question. We have now, we used to have 200 and some odd employees. They were all offered COBRA. Now I'm below 20. Do I still need to offer COBRA?
Well, did you
below
see,
20?
did you...
Well, it's, again, it's, did you have under 20 in the previous year? So if you go below 20 the current year,
I had above.
I'm sorry?
I had above
Okay,
previous year.
then basically what happens is you're not required to offer coverage in the next year.
So in the next year coming up, the benefit year or the calendar year?
It'd be the next,
Okay, so...
it would be the next calendar year.
Okay.
The next calendar year, not required to offer COBRA.
Correct.
And someone has mentioned to me something about federal and state coverage.
And again, I'll be covering that in the next few minutes. It all depends what state you're in. Many states have what we call mini COBRA. And so just because you get rid of federal COBRA means now you have to look at the state rules to see if you are subject to state COBRA.
If you want to choose whichever one is better for the past employee, can you choose to do so? Or
Well, no, the past employees continue to be offered federal COBRA.
Okay.
Just because you're under 20 doesn't mean that their COBRA goes away. It just means for any new employees, they would have to be offered state COBRA.
But if I want to give them federal, can I?
You can always be more generous. You can always be more generous.
That's what I wanted to ask. Okay.
Yes.
Thank you.
All right, we're running out of time. Let's make sure we cover all this. Why don't you mute everybody?
Mute, yep.
The conference has been muted.
Right. This next slide right here is extremely important. I know we have people listening all over the country. What's important is that generally in most situations, federal COBRA will offer more coverage than state plans. But there are states in the United States, California, New York, and others, that have they have 36 months as opposed to 18 months. So you have to be very careful. And generally the state COBRA will apply in many instances, not all, but many, where the contract is written. In Illinois, currently right now, there are, in most situations, state COBRA does not offer nearly as much as federal COBRA, but there are a few instances in Illinois. For example, for spouses, spousal coverage is 2 years, and in some situations, you could be offered COBRA for 10 years, for state COBRA for 10 years. So don't forget state law. In many states, not all, but many states, individuals would be entitled to the greater figure, the greater coverage, whether it's state or federal. Don't assume, unless you read the statute, that state COBRA only applies to small employers. Some do, some don't. So this is a general just warning to you, just to look at state COBRA, make sure, and again, state COBRA only applies to insured plans. So if you're self-insured, don't worry about it. But if you're insured, check the state law where your contract is written, just to make sure there aren't situations where you're supposed to offer either a child, a spouse, or an employee a greater amount of coverage, because there's greater amount of coverage on the state level. Now, a very common mistake is this next one. not sending required notice, or providing inaccurate or insufficient information. What you're supposed to do when there's a COBRA qualifying event is send qualified beneficiaries with specific notices explaining COBRA rights with very specific requirements as to what information must be included in these notices. To make sure that you comply, you may want to use the model notice and the model general notice and the model election notice. I'm not a big fan of these notices because I think they're too technical. I like things that are explained in English as opposed to legalese, even though I'm an attorney, especially if you're sending something to employees. But if you want to make sure you hit all of the cylinders and you're compliant, you may want to use those notices. Also, it's important to check and see that everyone who's terminated employment is excuse me, is given a notice. I just had a situation a few days ago where it was discovered that the person working at the employer wasn't sending the COBRA administrator all the terminated employees. 4 or 5 were left out. And so those individuals who were not given the required COBRA notices, they weren't given COBRA. In the event that a qualified beneficiary asserts that he or she did not receive a COBRA notice, you have to have valid records to see when you sent notices and when you didn't. And consider using a form of delivery if you're sending out COBRA notices that provide documentation that the notice was delivered. Because one of the biggest arguments people had, well, I didn't elect COBRA because I never got the notice. So here, if you want to protect yourself, you may want to, again, and avoid any hassle, do a return receipt or written proof of delivery. Now, to correct a not COBRA notice provided, make sure that when you discover the mistake, you send or resend the notice. No COBRA coverage provided. Consider offering retroactive coverage, but again, there are situations. I had one where it was years. And the common situation I've discovered, and this comes up, where you have an employer that for some reason hasn't terminated employees after they've terminated employment from their health plan. These employees keep on sending in the checks. The employer keeps on, the insurance company doesn't know any difference, and these people continue to be covered even though they terminated months or maybe years ago. What do you do in that situation if no COBRA notice was sent, no termination would happen, nothing happened, and they've been on your coverage for 6, 8, 10, 12, 15 months? Do you just cut them off and say, sorry? No, I would suggest not doing that. Depending on how many months have transpired, I would consider offering retroactive coverage. But again, you have to talk to your insurance company to see whether that's possible or not. If that's not possible, then you consider offering COBRA coverage when the notice is very late. And you may have to give them additional coverage because of not sending any COBRA notice or providing any COBRA coverage. So an employer that discovers a failure to offer COBRA coverage should take immediate steps to correct the issue. Urgency, because the fact is excise taxes with the IRS. ERISA has $110 per day statutory penalties for failure to provide certain notices. Lawsuits to comply coverage, increase risk of adverse selection, and possible inability to terminate COBRA coverage even if the qualified beneficiary becomes covered under another plan. So these are all issues and problems that have to be fixed when a COBRA notice is not provided. Also, make sure when COBRA notice is sent that it's sent to the employee and the spouse. Now, in certain circumstances, COBRA notice must be given not only to the employee but also to the spouse, and other qualified beneficiaries. Now, a plan will generally satisfy this requirement if the employee and the spouse in furnishing one single notice if they're living at the same address. So there's no problem. You want to address it to both people. But you have to make sure you have current information because it could be there's a divorce, qualified beneficiaries are living in other places like children, and those COBRA notices separate COBRA notices have to be given. Now, generally, there's no requirement to a separate notice to dependent children who share the residence. But again, if you have, because of the age 26 rule, the issue and problem is going to be that what happens if those kids are living on their own? The father terminates, the mother terminates employment, and all of a sudden now you have to offer coverage to the entire family, and you have to make sure that you have the addresses to make sure you send out the COBRA notices to the right individuals. So to minimize the possibility of errors involving a notice recipient's employee should be required and periodically reminded to notify the plan administrator promptly of any separation, divorce, or other events that results in a spouse or dependents no longer living in the same address. And this is a real issue, and again, especially if you have employees with children between the ages of 18 and 26. And the plan should have procedures in place to ensure that any changes in the address are promptly and accurately recorded. Another situation is not recognizing when a qualifying event has occurred. The employer is responsible for notifying the plan administrator within 30 days of termination or reduction in hours of service, death, or if the employee, if you're under 20, becomes entitled to Medicare. So these are situations you have to make sure if you're using a COBRA administrator that all these different events are communicated to the COBRA administrator. So a reduction of hours requires whenever there is a decrease in hours. And this is kind of, the problem is going to be in this discussion right here, especially if you have a reduction of hours. In some situations, you may not be able to terminate the coverage right away, especially if somebody is going from full-time to part-time, because remember, everybody is going to be in a stability period, and it may not be possible in some situations to terminate coverage immediately and offer COBRA. So just remember that. Stacy, why don't we stop right here and see if anybody has any, if you have any questions or anybody else.
Okay, I do not have any on my end. Let me unmute.
The conference has been unmuted.
Does anybody have any questions?
I have a question about notification. If the employee does not have family, can that employee be presented with the COBRA notice at the time of departure? And also, what about emails if the employee gives the permission to send an email notification?
You can do an email if the employee agrees to that. Also, remember, if at the time of termination, if you give them a COBRA notice, I would advise you very strongly that they sign something indicating they received it. Because you have to have proof of delivery. So therefore, if you're going to hand deliver a COBRA notice to an employee at their exit interview, and say, here's your COBRA notice, as one of the exit interview pieces of paper saying, I hereby acknowledge I've received my COBRA notice. So therefore, you can prove the fact that they were actually provided a COBRA notice.
Got it. Thank you.
Any other questions?
I have one that popped up here. We are pursuing a dependent verification audit to ensure our covered dependents are valid. If we find that someone is on the group plan but is not an eligible dependent, and we are dropping them as not an eligible dependent per plan design rule, does this meet the two conditions of losing benefits and experiencing dependent loss coverage?
I would say no.
Okay, and then it says concern is they are not eligible dependents once researched.
Right.
Okay.
Correct.
Okay.
You're rewarding somebody that never should have been on the plan.
Okay. And then one last question. If an employee's spouse gets insurance through their own employer, and therefore we take them off our insurance, do we have to offer COBRA?
No.
Okay. All right, let me mute. And then
The conference has been muted.
Miscalculating the period of coverage. There's a couple of times this is real important, especially, and what many employees don't understand, there's a second qualifying event that will extend coverage. If somebody terminates employment, and the whole family gets 18 months, and then that after that COBRA qualifying event, that employee dies, or they get a divorce, then the family members are entitled to a greater period of time. It's important as an employer that any of the material that you have that explains COBRA, that you basically go into detail about this, and that you explain to the employees there are other situations that could allow you a greater period. So employers must offer employees and other qualified beneficiaries the maximum period of COBRA. The type of qualifying event determines, again, how much period of time you offer them. Also, another situation that extends COBRA is in situations where somebody becomes eligible for Social Security disability. And they're eligible for, again, an extension of 11 months for a total of 29 months. But they must be determined to be eligible for Social Security disability within that 18-month period. And they have to be shown to be disabled, I think, the first 60 days of COBRA coverage. And that's another situation that should be explained to the employees so they understand that only in certain circumstances that they will be getting this additional 11-month extension. And the reason for that 11-month extension is to allow individuals to get to Medicare. That's the purpose behind it. So again, your plan rules as well as your election notice for any offer of 18 months should describe the notice required and when that person can request an extension for COBRA. Has to be very clearly indicated. In general, I put that in my general notice and also my election notice. Also, please remember there are special rules for health FSA in the fact that if most FSAs are accepted benefits, and because of that, you only have to be offered coverage to the end of the plan year, and you only have to offer coverage, COBRA coverage on the health FSA, if the coverage is underspent. So if no COBRA coverage has to be offered if the count is overspent. And that's got to be also explained, and I don't see that many places in COBRA notices that's explained. Now, this next issue is a very common question. A health plan may charge up to 102% of the applicable premium, and then 150% for the disability extension. You can charge less than that if you want, but that's the limit you have to charge. For insured plans, usually equal to the insurance premium paid to the insurance provider, it gets a little stickier in regard to self-insured plans. The calculation can be more difficult for self-insured plans, self-funded plans, because they're using past costs and actuarial So the applicable premium is the total cost of providing coverage. And that COBRA premium is calculated on a premium for an advance for a 12-month period. And the plan can choose a 12-month period for this determination period, and it must remain constant from year to year. And again, many employers pick the renewal date for changing the COBRA premium. That's just logical. But if you make a mistake, the COBRA premium may only be changed for the new determination period. A COBRA premium may be charged for a new determination period if the applicable premium changes, and therefore certain limited situations. And again, you should use caution and be very careful in calculating COBRA premiums. Fixing mistakes that result in either overestimating or undercharging qualified beneficiaries for COBRA premiums can be administratively burdened and raise COBRA compliance questions. Also, too, qualified beneficiaries may be required to pay the full premium for COBRA continuation coverage, even if the employer made a contribution prior to the loss of coverage. And the plan may allow premiums to be paid on a monthly basis. Now, if the amount of the premium made to the plan is wrong, but is significantly less than the amount due, the amount is paid will be deemed to satisfy the plan's requirement for the amount that must be paid unless the plan notifies the qualified beneficiary of the amount of deficiency and grants a reasonable period of time, not less than 30 days, to pay the difference. This is something right here that many employers don't really understand and know. And it may go unnoticed that that amount is incorrect. And all of a sudden now, no request has been made. And that individual keeps on paying the wrong amount. So even if the plan does not send out a monthly notice, it must provide this notice of underpayment, or the amount submitted will be treated as a full payment. Now also, and I think this is a very common problem, the very common problem is a situation where the employer hasn't written down all the rules in regard to COBRA to make sure everybody understands how everything works. So continuation coverage offered under COBRA must be identical to the coverage that is currently available under the plan. And in this situation, remember, when somebody is on COBRA, in essence, they're treated as the same as active employees. The same coverage has to be offered, the same choices have to be offered, the same alternatives have to be offered. And if an employee has a qualifying event, the COBRA participant can add beneficiaries, dependents. So please remember, and this is something that sometimes employers forget, that an individual, even if they have elected dental and vision, and they're given dental and vision at the time of the qualifying event, if they have a special qualifying event, just like any other employee, they can have the ability to elect medical if they didn't elect it before. At the next open enrollment, they can elect medical if they didn't have it before. So they're treated as any other active employee. Another situation that would happen if terminating COBRA coverage are too early. There are very specified rules regarding the COBRA coverage may terminate prior to the expiration of the maximum period of time, and these are cited here. Premiums are not paid in full. The employer ceases to maintain a group health plan. The qualified beneficiary begins coverage in another plan. And this is very interesting. What people confuse, a few years ago, I think in 2009 or 10, there was a COBRA special payment because people were losing their jobs. But you were not eligible for the special payment if you're eligible for other coverage and didn't take it. And people confuse that with the COBRA rule that says that COBRA coverage technically cannot end until somebody actually begins coverage. Just because you're eligible for coverage doesn't mean that COBRA ends. So please understand that and remember that there's a difference between the COBRA rules, and there was a special COBRA rule about 4 or 5 years ago. The qualified beneficiary becomes entitled to Medicare. But there's rules in regard to that, and sometimes that rule doesn't apply. And then the qualified beneficiary engaged in conduct that would justify the plan to terminate coverage, such as fraud. If continuation coverage is early, the plan must provide, and this is something, a qualified beneficiary with an early termination notice. This notice must be given as soon as practicable after the decision is made and must describe the date coverage ends and the reason for the termination, any rights a qualified beneficiary may have under the plan to elect alternative coverage. Also, to the rules, the relationship between Medicare and COBRA are pretty complicated. Here, an employee, spouse, or child who loses group coverage because the employee becomes entitled to Medicare may elect up to 36 months, where the spouse or child already is receiving COBRA to the employee's termination or reduction of hours. The employee is becoming entitled to Medicare may be a second qualifying event, which will allow the 18-month period to extend another 18 months. Remember, Medicare does not affect COBRA if somebody was receiving or entitled to Medicare when they became entitled to COBRA. So if I turn 65, I'm entitled to Medicare. I elect Medicare. I get terminated in my employment. My entitlement to Medicare doesn't affect COBRA. Whether an employer or family member is covered by Medicare may affect the right of continuation coverage. And again, the first rule I just indicated, if a qualifying beneficiary first becomes entitled to Medicare on the date before the day the COBRA is elected, the qualified beneficiary's entitlement to Medicare cannot be a basis for terminating continuation coverage. If a qualified beneficiary first becomes entitled to benefits after the date on which the COBRA continuation coverage elected, the plan may terminate the qualified beneficiary's coverage. All right, but again, it doesn't affect the family members. A qualified beneficiary who becomes entitled to Medicare upon an effective date of enrollment in either A or B. So just because you're eligible for COBRA and don't elect COBRA doesn't affect, again, your entitlement to COBRA. Unfortunately, making sure that you provide notices in certain situations isn't always enough. It's important to make sure that the notices provide, again, the required information. Make sure they're correct. And there are several COBRA rules that require a plan to have procedures in place, and especially if you look at the general notice requires you to have established procedures for giving notice of qualifying events. That's got to be specified, who you give notice. So look at your general notices to make sure those rules are applicable. So notice procedures with respect to notice plans must have reasonable procedures. Qualifying events such as divorce or legal separation or a dependent child losing dependent status. Again, you have to indicate who you give notice to. Also, who do you give notices to second qualifying events? That's got to be specified in your general notice. And including the Social Security Administration disability determinations, who you give that notice to. In order to be reasonable, the procedures must be described in the SPD, specify the individual entity that should receive the notice, specify how the notice must be given, describe the information required, specify the timeline for giving notice, and provide the proper handling of incomplete notices. So all that's going to be specified and is going to be communicated to the employees. Now, a very common problem, and again, this is another situation that I had just a few days ago. Upon retirement, if you as an employer provide a retiree coverage, some employers think, well, because we were providing retiree coverage, we don't have to give a COBRA notice because we're providing this coverage to our employees. Well, in order to have a COBRA qualifying event, there has to be two things, as I indicated earlier. There has to be a qualifying event, which is retirement, bingo, and there has to be loss in coverage. Well, some people argue, well, there's no loss of coverage because we're providing the retiree coverage. So I further ask, is this coverage is identical to the coverage offered to active employees? And sometimes it is, sometimes it isn't. If it isn't, then that's a loss of coverage. If it is the same coverage, then I ask, well, do the retirees pay the same amount as the active employees? And 9 times out of 10, the answer is no. And many times, for active coverage, the employer will pay anywhere from 75 to 80% of the premium, sometimes more, sometimes less. For retiree coverage, it could be in the range of 30 to 50%. That difference is, by the government, is considered to be a loss of coverage. And the issue and problem is, if you don't, again, give out a COBRA notice at that time, at the time of retirement, if in some time in the future that retiree coverage ends, at that point you have to offer them COBRA. So again, extremely important to understand, if you want to cut off the retiree's right to COBRA, you give it to them at retirement. Are there any questions?
Okay, yes, I have a couple here. Okay, if an employee's spouse gets insurance through their own employer and therefore we take them off our insurance, do we have to offer COBRA?
No, there's no qualifying event.
Okay. So if the spouse has other coverage and we drop them from our insurance, no COBRA notice is needed, but do we need to get documentation that the spouse has other coverage?
No, because in fact, just because someone's dropping coverage, the reason is not important.
Okay. What is a disability extension?
A disability extension is if somebody is eligible and it's any qualified beneficiary, if they become eligible for Social Security disability benefits, and that determination is made within 18 months of COBRA, and they've determined they were disabled within the first 60 days of COBRA, then that employee and their family can be entitled to an 11-month extension of COBRA.
Okay. And then last question I have, do you have to offer COBRA coverage to associates who have an age reduction of benefits for life insurance, company paid and or supplemental?
That's not a qualifying event under COBRA.
Okay. Okay. Okay, let me go ahead and unmute for questions.
The conference has been unmuted.
Does anybody have any additional questions?
Yes, please.
Go ahead.
Yes, I have. Oh.
Go
Okay.
ahead.
You had stated that if an employer
spouse gets insurance and we have to take them off our insurance, we do not need documentation or justification why we're taking off their insurance. So
If the employee
if it's
requests it now, one situation that could be troublesome. I just thought of this. If it's anticipation of a divorce. Because in that situation, if that person takes the spouse off because he's divorcing the spouse, and he's doing it because the divorce is going to be final in a few weeks or a few months. In that situation, the spouse is still entitled to COBRA. So that's one exception I just thought of.
okay, in this case, during our open enrollment, we don't have to justify that. However, if it's throughout the year, the underwriters of the insurance have asked for us to send over that proof that the employee
it's different, right, because you can't take them off unless there's unless it's a qualifying event, right?
Okay, so that is correct that we would have to, or if the underwriters ask for that documentation, we would have to prove that.
Because according under the insurance contracts, only in certain situations can a family member be taken off during the policy year. So you have to fit one of those situations in order for that spouse to be taken off.
Okay, thank you.
Any other questions?
Yes.
Mm-hmm.
If someone previously had medical...
I'm sorry, could you speak a little louder?
Yes. If someone had medical and dental coverage previously, they were offered to COBRA, and they chose to just select medical at the time, and our open enrollment then came around, and they then wanted to elect medical and dental. Because it'd be an open enrollment, that would be the qualifying event that would allow them to add
Remember,
on
they're treated just like any other active employee, and they have a right to be treated during COBRA just like any other active employee. So in that situation, in the next open enrollment, they have a right to elect additional coverage.
So even if they didn't even have medical, say, because we have medical and dental separately, but if they had only had dental to begin with, because I thought they were eligible for what they currently had in effect.
Until either a qualifying event or until the next open enrollment.
Okay, so at the next open enrollment, they can then elect medical.
Or if they have
Or spouse or dependents, etc.
Right. If they have a special, like if they get married, the spouse loses their job, that type of thing, then they could add their spouse to the plan. And at that point, they could add medical then. So just like any other active employee, they can change their coverages, add coverages at open enrollment and at special enrollment events.
And if I may add to what she said, I have had employees that have done state assistance insurance or like some other type of state-approved policy, and they are on that during their waiting period for their new hire, I should say, their eligibility date, which is like the 3 months in. So at that point, we've been able to add them, or there has been some employees who have decided not to take the company insurance and stay on that. I let them know that there could be an audit performed and they could be denied benefits, meaning then the following month they would get a letter from let's say the state saying you are no longer eligible because your employer offers you insurance. And so at that time they come, and because it's a life-changing situation.
Well, in some states, eligibility for employer coverage does make you ineligible for Medicaid. Many states don't have that rule. Some states
interesting.
do.
Okay, thank you.
Some states do, some states don't.
Okay.
Any other questions?
We have a question.
Mm-hmm.
COBRA mistakes, the last bullet says qualifying event has occurred and it's covered.
So let me get there. Bear with me a second. Oops, sorry. There's no slide numbers on here.
Oh, sorry.
So what does the slide say? I'm sorry.
It says common COBRA mistake, and then the title, recognizing when a qualifying event has occurred. And there's 3 bullets.
Okay, just let me. I'll go to the beginning.
Go back one.
This one?
Yes, the last bullet. We're a little unclear as to why the covered employee becomes entitled to Medicare.
If you're under 20. If they have a reduction of hours, and you're under 20 and become eligible for and entitled to Medicare, they sign up for Medicare. It's a very, very limited exception.
Under 20 hours?
If you have a reduction of hours,
Okay.
and you're under 20 employees, because if you're 20 or more employees, the Medicare secondary pay rule says you can't do this.
That would only happen if they in COBRA a year prior. Now we're under that.
Are there any other questions?
I have a couple that came in last minute here. Can't it be argued that COBRA is a continuation coverage, so they could not be offered at OE?
OE?
Yeah, I don't know. Open enrollment. Maybe she meant.
Open enrollment, thank you.
Yeah, I think she just meant.
No, I mean, it's very clear from the rules that they have, they're treated just like active employees.
Okay. Can the plan allow an employee to drop a dependent's coverage without any reason, any qualifying event?
Could you repeat the question again?
Yes. Can the plan allow an employee to drop a dependent's coverage without any reason or any qualifying event?
Not during the year, but open enrollment, yes.
Okay. And then, so anytime an eligible employee removes a dependent throughout the year, they must provide proof.
Yes, because the insurance contract requires that you can only drop a dependent during the year if you have a qualifying event, according to the insurance contract or to the plan document.
Okay. And then if someone waives initial COBRA for all plans, do we have to offer COBRA to anyone who waived but are still within their projected COBRA time frame?
You mean during the 60-day period? Yeah, they can still elect.
Okay. Even though they initially waived, they can, if
Right.
they're in that, they can, okay. Okay.
I have a question on Medicare and COBRA.
Mm-hmm.
If you have offered them COBRA and you were talking about them turning Medicare age, as soon as they go on Medicare, then Medicare becomes primary versus your company insurance. Is that correct?
If you're, is this a former employee or is this an active employee?
They are a former employee. They've been on COBRA. They turned 65. They elected Medicare while they were on COBRA.
Well, remember, COBRA coverage is not considered to be employer coverage. So in that situation, COBRA coverage is always secondary to Medicare. And what many insurance companies do, even if you don't elect Medicare, they pay secondary. So if you are eligible for Medicare, don't elect it. Some insurance companies will then only pay secondary to Medicare, forcing you to elect Medicare.
Right. Then if say your company is paying subsidizing your COBRA,
Mm-hmm.
does that qualify then as active coverage? Does that keep you from
No,
having
you
that
have-
switch
no.
change? Okay. Okay.
I have a question as well. And this goes back to the open enrollment question that we had a few moments ago, but we're saying that if I initially waive medical, elect dental, that at an open enrollment period, I have to be given that option to elect medical. And I think where I'm confused then is if it's not based upon what they had when they first waived COBRA or what they picked at that point, if I waive all of my COBRA benefits, then wouldn't that denote that we have to offer even waived folks the plans since
No.
they're...
No, I mean, if you continue, no, in that situation, once you waived all your coverage, once you waived COBRA coverage, then you have no other rights.
Okay.
By picking, like dental and vision, you have preserved your rights, and therefore at next open enrollment, you can elect medical.
Medical. Okay. So it's about preserving your right to
Correct.
any plan that was
Correct.
offered. Okay.
Correct.
All right, that explains it. Thank you.
Good question. Any other comments? Well, I hope you found this helpful. We've covered a lot of material today. And again, our next session is April 19th at 1 o'clock Central Standard Time. We're going to be talking about HRAs and what's happened over the last couple years with HRAs. And I'm going to go through all the different rules that affect HRAs. And there's been some important ones over the last 6 months, but I'll be covering all of them. If you have an HRA or thinking about HRA, please consider attending because I think it's going to be important. Because one of the aspects of HRA under the ACA, you have to give an employee each year the right to waive coverage. And I review a lot of HRA documents, and this is one thing that's missing from many HRAs. All right. Well, thank you very much. Stacy, thank you.
Thank you, everyone. Thank you so much. Have a great day.
Bye-bye.